Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 250 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues, we've been providing advice and assistance to both employers and employees on all aspects of employment law since November 2013. If you are a business and you're looking for ongoing support in relation to HR and employment law, or you're just feeling a bit overwhelmed with the prospect of all of the changes that are coming with the Employment Rights Bill in 2026, then why not get in touch? I'd be happy to have a chat with you and provide you with a no obligation quote so that myself and my team can help to take away that stress and worry for you. So if you'd like to arrange a telephone call or a discussion over Teams about your situation and any help that we can offer you, please don't hesitate to get in touch. My email is alison@realemploymentlawsadvice.co.uk. So without further ado, I'm going to get into this week's featured content. Okay, so in this episode of the podcast, I want to talk about warnings. Now, the reason why I thought we would cover this off is because of late, I've been asked fairly frequently to advise people on giving warnings in situations in which they haven't gone through any formal process and don't intend to, or in a situation where an employer has sought to rely on cumulative warnings to justify dismissal when it gets to the kind of final stage of things. So where an employee does something which wouldn't of itself constitute gross misconduct, but when you take into account the previous warnings, would potentially justify dismissal. So it is something that people are using in relation to performance management, capability, and also some minor conduct issues. So I thought it'd be useful to talk through warnings from my perspective and give you a bit of a refresher in relation to the process that's required. So what is a warning? Well, a warning is a formal step, essentially, to address conduct, capability, or performance. And when you think of a warning, in the most cases, and what we're talking about today, we're talking about formal warnings. Now, of course, you can use informal warnings, but in my view, you're better off terming them as something like an informal discussion or a management discussion or something like that, rather than calling it an informal warning, because it can create some confusion with employees about exactly whether it's formal or not. Now, a warning can be in writing or it can be verbal. And quite often you'll see in disciplinary processes that the first stage of a disciplinary process is a verbal warning. Now, it can be quite tricky in relation to verbal warnings because obviously the advice following giving a verbal warning is to put that in writing so that you have a summary for the employee. So really, my advice is that you should avoid using verbal warnings. And if you are going to have a more informal discussion, then you should do so under an informal process rather than a verbal warning that you then follow up in writing, because it can be quite confusing for individuals to understand exactly what it is you mean. So why would you give someone a warning? Well, I'll tell you first off why I think lots of employers and managers do give warnings, and then I'll tell you why I think you should give warnings. So in my experience, warnings are used inappropriately by managers and employers because they want to avoid having a difficult conversation with an employee. So rather than have that difficult conversation and explain things and go through, the tough side of managing a person, managers will instead give them a warning because it's easier to do. The other reason why I think managers often give warnings is because they don't have time to properly manage employees. So they don't have the time to go through with them, to tell them exactly what is required of them and to discuss it. And they don't have the time to train and develop employees. And so I think they're used inappropriately in those circumstances where managers just don't have the time to manage. It's easier to issue someone with a warning. Another reason I think they're used inappropriately is as a punishment. I don't think we should be thinking about any employees being given a punishment. We're all grown-ups. The people you work with are grown-ups and we should be able to talk to each other in an appropriate way. It's not about punishment at all. And I think sometimes that then leads on to the final point as to why managers give warnings, which is there's this mistaken belief that by giving a warning it will change behaviour. Now, of course, issuing a warning as part of a process of development and supervision can, of course, help to change behaviours, but the mere giving of a warning as a punishment in order to elicit change is misguided in my view. So why should you give warnings? Well, the circumstances in which you should give warnings, in my opinion, are when there is something that's taken place which is serious enough to warrant formal action. So some kind of one-off misconduct that doesn't require dismissal, so it's not serious enough to justify dismissal, but it is serious enough to warrant some formal action. And that brings on to the second point. So if it's like a one-off conduct issue and it's serious enough, then I would say that it's appropriate to use the disciplinary process to issue a warning. The next time I think you should use it is when you've exhausted informal improvement measures. So once you've been through a full process with somebody of improvement and you've taken the time to manage them properly, to train and develop them, to have those difficult conversations, and you've exhausted that informal process, then I think it's appropriate to go through the formal process to give them a disciplinary warning. Or it might be that it's part of a wider improvement plan, so you're partway through an improvement plan and things haven't improved. That's another time in which it's appropriate to give a warning. And then finally, warnings should be used, in my view, to give people a fair opportunity to improve. So the purpose of a warning is to give someone an opportunity to improve, not as a punishment. So what exactly is the correct process for issuing a warning? Now, I said right at the beginning that one of the reasons for doing this episode of the podcast is because of the frequency in which I've found that employers are just issuing warnings without having any further discussion, conversation or process with an individual. And so it's important to highlight exactly what the procedure is. Now, of course, you should have a disciplinary procedure contained within your own policies and processes or staff handbook that covers this off. But in any event, as a very minimum, the process should include investigating the issue and gathering information about the issue that you want to discuss with the individual that could result in the warning. Then you provide that information to the individual involved and invite them to a disciplinary hearing in accordance with your process and tell them that they have the right to be accompanied at that meeting. So the purpose is to get all the information together, to be transparent and share it with the employee and invite them to a meeting where they have the right to be accompanied and they understand what the meeting is about and the possible consequences. The next step is, of course, to hold that hearing and listen to the employee's response. Now, ideally, if you have enough resources within your organisation, the investigation stage should be dealt with by somebody different to the person who deals with the hearing, so as you have separation from the gathering of the information. Now, it might not always be possible if you have a smaller organisation, or it might not always be appropriate in the circumstances if it's a performance issue or something like that. It might be better that the manager who's involved on a day-to-day basis is able to gather that information and then hold the hearing. Then after the hearing and you've listened to the employee's response, then you make a decision about what to do next. So it might be that you can make the decision immediately after that hearing, but sometimes you might have to make follow-up inquiries and then decide on the outcome. And of course, then you should inform the employee and follow up. So if the employee is issued with a warning as a result of the hearing, then you should include the details in a letter, but then also follow up with the employee afterwards to ensure that they understand fully what's happened, what the consequences are, and what is required of them going forward. And finally, you have to give them notification within that follow-up communication that they have the right to appeal. And if they wish to appeal, you go through the appeal process with them. Now, once you've been through the process and the procedure and you're contemplating the sanction to give the individual employee, it's important to consider what type of warning you're going to give and be guided by your own internal procedures. Now, hopefully your internal procedures are wide enough to give you this discretion to apply it on a case-by-case basis depending on the circumstances, but you need to be guided by what your internal processes say. And the ACAS code recommends that you give at least one chance to improve before a final written warning. So it may not always be appropriate to go straight to a final written warning, unless, of course, you can justify that and it's fair and reasonable in all the circumstances to do so. So if it's the first instance of misconduct or poor performance and the first time you've been through a process with someone, then normally the fair and reasonable approach is to give them the first written warning. Now, you can, of course, take into account any previous warnings or live warnings on their personnel file. So if they already have a written warning, then you can then utilise that to say, right, actually, you've got a live warning, so this is going to be a final written warning. But again, you've got to look at what all the circumstances of the case are in order to justify it. And once you've issued a warning, how long should that warning last for? Well, again, you should be guided by your own internal procedures, and you should set out in writing when issuing the warning the period of time that it's going to remain live. And ultimately, this is down to you as the decision maker, but you should be guided by your internal processes. Now, if you issue a warning and the period in which it's going to stay live is beyond what is set out in your procedure, then of course you can do this as long as your procedure isn't contractual. You can, as a decision maker, use your discretion, but you should of course clarify your reasoning for that when you issue the decision. So for example, if your process and procedure says for this type of misconduct, a first written warning would normally remain live for 6 months, but in this situation you've decided you want it to remain live for 9 months, then you would need to set out exactly why you have decided that in your decision. Now, there may be circumstances in which you want to have a warning that lasts for an unlimited period of time. So you don't want to have a time in which that is no longer considered to be live. And it might be that there are circumstances in which it's appropriate to do that. One of the things that sometimes comes up with employees is where they are given a warning for either a conduct issue or a performance issue, and then they manage to maintain their conduct or performance just long enough for the period of the warning, and then as soon as that warning expires, something else happens or their performance slips. And in that situation, what I've said to employers in the past is you can justify the decision to make that warning unlimited by saying to them, actually, we've been through this process with you at least twice before, and in both occasions, as soon as the live warning has expired, we've had a repeat of the conduct or performance issues that we have dealt with before, and therefore this warning is going to remain on your file for an indefinite period of time and will be taken into consideration in relation to any future misconduct. And again, it can be quite a good tactic for those employees who play the system, if you like, and manage to kind of toe the line long enough so that they don't move up the next level of warning or to a dismissal, but then they're kind of repeat offenders. So you can give an unlimited warning, but it's important, again, to set that out in writing as to why. So what about expired warnings? If you are dealing with a disciplinary process or procedure in which a warning has expired, but the conduct that you are referring to is the same or very similar to the conduct you're dealing with now, can you take into account expired warnings when deciding on the outcome in a fresh set of proceedings? Well, in some circumstances, you can justify reliance or reference to an expired warning in relation to another more harsher sanction or in relation to dismissal. Now, the non-statutory ACAS guidance summarises the position as being that a decision to dismiss should not be based on an expired warning, but the fact that there is an expired warning may explain why the employer does not substitute a lesser sanction. So in circumstances in which you may not necessarily have been able to justify dismissal for that incident alone, you can justify your decision of not issuing a final written warning, for example, and moving straight to dismissal because of an expired warning. Now, it's important to keep in mind that if you are relying on any previous warning, especially in relation to a dismissal decision, that you have to ensure that the procedure and process that's been followed for those previous warnings has been fair and reasonable. Otherwise, it's going to be very difficult to justify your decision to dismiss based on those previous warnings. So why is it important to ensure that you follow a fair and reasonable procedure? Well, aside from the legal risks, you have to ensure, of course, that the employee understands exactly what the issue is and also has an opportunity to respond. You're not going to get the best out of that person if you're issuing them a warning and they haven't really got a clue about why it is, or they feel so unjustified about the situation and they've not had an opportunity to talk it through with you. You're never going to get the best out of that person by issuing them with a warning. And actually, it's more likely to cause further issues down the road between you and the relationship between employee and employer. Another reason for ensuring that you follow the correct procedure is that it ensures consistency and fairness of treatment across all employees. So if you have managers who are going off on a frolic of their own, doing whatever they want, disregarding the procedure, issuing warnings here, there and everywhere to some employees and not to others, then it can create this sense of unfairness, but also put you at risk in relation to potential legal challenges in regards to how employees are dealt with. And of course, that goes on to the transparency piece. If you're going through a fair and reasonable process when you're issuing warnings, it ensures transparency in the process and helps to create that trust. And ultimately, if you aren't doing things correctly, and if you are issuing warnings here, there and everywhere, it is going to lead to a loss of trust and confidence amongst the staff more widely. So if you do get the procedure wrong or you don't follow a procedure, as we said, there are some significant legal risks. And of course, the most important one to consider is in relation to the use of cumulative warnings to dismiss somebody. So if you have used previous warnings where no process has been followed, then your decision to dismiss is going to be immediately open for an unfair dismissal claim. Now, aside from the risk in relation to unfair dismissal, an employee could also, of course, raise a grievance if they feel aggrieved about the way they've been treated. You're unlikely to get any improvement, and in fact, you'll end up with a disenfranchised employee who doesn't really care about the warning that's been given to them. And of course, you could also find yourself on the wrong end of a constructive unfair dismissal claim. And there have been cases involving situations where employers have used warnings inappropriately, and employees have successfully resigned and claimed constructive unfair dismissal. And there can, of course, be an increase in compensation if an employee is successful in an unfair dismissal claim and you failed to follow the minimum ACAS process under the Disciplinary and Grievance Code of Practice. And there could be up to a 25% increase in compensation as well. So it could be quite costly in relation to that. Now, of course, I've talked about the legal process and the minimum procedure in relation to issuing warnings. And right at the beginning, I did talk about why I thought that some employers and managers use warnings inappropriately. Now, I actually think that it's really good HR practice to use warnings and the formal disciplinary process in particular as a last resort. Now, thinking back to what you want to get out of the process, actually issuing a warning in most cases is seen as a punishment by individuals, and you're not always going to get what you want out of it. And sometimes, as we said, managers use warnings as a lazy way of managing. So actually, my view in relation to the issuing of warnings is that you need to have a few more steps in place before you even get to the formal process. So I actually think that good management involves asking yourself some questions first as the manager before you even start to talk to the employee about the issue. And this is particularly important when we're talking about performance or capability issues. Now, obviously with one-off issues or incidents of misconduct, again, I think you should still ask yourself the questions, but it doesn't necessarily apply or is as important in relation to those issues. But certainly if you're looking at doing warnings regarding conduct, minor conduct, such as things like being late, that sort of thing, or performance or capability issues, you should ask yourself the following questions. So number one, does the employee know what is required or expected of them? So really ask yourself, does this person know what is expected of them? So let's take, for example, being late for work. Does the employee actually know when they're required to attend at work and what is expected of them when they start? The second question is, have you been clear in your expectations to them? So do they understand exactly what is expected of them? And have you been clear about that? The third question, does the employee know how to do the job? So have they been given sufficient training in order to do the job? And then finally, you should ask yourself if they have a disability or they need any other additional support for any other reason. So once you've been through those questions, if you have gone through those and you're satisfied that the employee knows what's required of them, you've done everything you can to ensure that they've had the support and training, and you've been clear on your expectations and they don't have any requirements for additional support that haven't been met yet, then you can move on to the next part, which is to ask yourself if this will be the first time you have discussed this with them. Now again, one-off issues of conduct, you're not necessarily going to do this, but everything else, then you do need to ask yourself this. Will this be the first time you've discussed it with them? And if the answer to that question is yes, this is the first time, then I would suggest you need to start with an informal discussion. So have an informal discussion with them and perhaps issue them with a management letter setting out what's required. Now, if you have already discussed it with them, this isn't the first time, then the next question to ask yourself is, do you think it's appropriate and reasonable to go through the formal stage of the process? So again, putting in that other level of checking yourself. So you've been through the process of looking at the questions, you have already discussed this issue with them. So the next question is, do you think it's reasonable to go through a formal process? And if the answer to that is yes, then of course proceed through the informal process as we were saying earlier. But if the answer is no, then you need to think about a further informal discussion with some measurable timescales for improvement, so being very clear and explicit about what is required. Now, each of those things I've just talked about are not legal requirements. They are my advice in relation to good practice and good management. And I do think if you go through that and then you find yourself in a formal process with an employee, you could genuinely say to yourself, I have done everything I possibly can to avoid getting to this situation, and I'm therefore going down this path with the individual. So you've done everything you can as a manager or employer to ensure that they are successful or as successful as possible, and they still haven't done that, then you can be justified in going down the formal process of issuing warnings, etc. Now, in relation to some frequently asked questions about warnings, there are a few things that come up fairly often. And the first one is about employees who consistently adhere to regular standards during the warning, then it lapses as soon as that warning has expired. And one of the questions we're frequently asked is, can you give an indefinite warning for future conduct? And as I was saying earlier, yes, you can, as long as you set that out very clearly to the individual. And, there's nothing wrong with saying to them, I have noticed that every time you're issued with a warning, things are fine for the period of the warning, but as soon as the warning ends, you lapse back into that behaviour again. And so for that reason, I'm going to give you a warning now which lasts indefinitely, which means that if there is a repeat of that behaviour or conduct, then you will be moved on to the next stage. The next question is, what happens to a warning if someone goes on family leave? So if somebody has an extended period of family leave like maternity, how do you deal with the warning? Do you freeze the period of the warning so it starts up again once they return, or do you let it lapse during their maternity leave or family leave? Well, the answer to this, in my view, is that you just let the warning continue, and therefore it may expire during their period of family leave. Because to do otherwise could potentially be seen as being discrimination on the basis of their maternity leave or family leave. So certainly if they've got a live warning and they go on leave for family reasons like maternity or paternity or shared parental leave, then it's not appropriate to pause that warning and then restart the live period when they return. And then what happens if somebody is on long-term sick leave and they have a live warning? Well, again, it's important to take into consideration the individual circumstances that might apply here, because if they have a disability, again, by pausing the live period of the warning and restarting it when they return could potentially be considered to be unreasonable treatment of them due to their disability. So you might be at risk of discrimination. And then the final question that we're asked quite a lot is about other sanctions. So can you apply other sanctions to them other than a warning? Things like demotion or suspension without pay. Now, the short answer is yes, you can, but you need to ensure that that is set out within your individual process or procedure and is very clearly set out before you do that. And if you don't have something set out in writing that enables you to issue another type of sanction, then it's important to seek some advice before doing so. It's much better to seek the employee's agreement to that if you haven't already got that set out in your policies or procedures, than to just apply it, because it could result in a potential breach of contract and therefore a constructive unfair dismissal claim. So to recap, in relation to warnings, you can, of course, issue a warning without following any procedure or process. However, if you do so, the first thing is it's really lazy way of managing issues at work and it's bad HR practice. You're not actually going to get the best out of employees by issuing warnings here, there and everywhere. It's important to go through the formal process as a very minimum before issuing a warning, particularly if you want to rely on that warning in relation to a future misconduct or a dismissal of an employee due to the combination of various things. And the best practice is to actually use warnings and the formal disciplinary or capability process as a last resort. It's much better to manage issues proactively before going through the formal process. You'll get the best out of your employees and it'll be a much better working relationship overall. So hopefully you've found that helpful. If you're listening to this episode and you think actually our disciplinary procedure is either non-existent or is not fit for purpose and you'd like that reviewed, or if you'd like some training for your managers in relation to how to handle processes or when not to go through the formal disciplinary or capability process and issue a warning, then that's something we can help with. We regularly train managers on not only what the law says, but also being a fantastic manager and being the best employer that you can. So if you'd like any more information, I'd be happy to have a chat with you. You can email me. It's alison@realemploymentadvice.co.uk. Thank you so much for listening to this week's episode of the podcast. I hope you have a fantastic 2 weeks and I look forward to bringing you the next episode of the podcast, which will be episode 251. Can you believe that? 251 episodes of this podcast. So that will be coming up in 2 weeks' time. Thanks for listening and have a great week. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.